For our next story, we have HIQ Labs versus LinkedIn. This is a case dealing with a company that was trying to scrape LinkedIn data and was being held liable for that. So we're going to reach the decision of the Ninth Circuit Court of Appeals on this case. The court affirmed the district court's preliminary injunction forbidding the professional network LinkedIn from denying plaintiff HIQ, a data analytics company, access to publicly available LinkedIn member profiles. Using automated bots, the HIQ scrapes information that LinkedIn users have included in the public. LinkedIn profiles, LinkedIn sent HIQ I think they mean cease, a cause and decease letter demanding HIQ stop accessing and copying data from the server. HIQ filed suit seeking injunctive based on California law and declaratory injunction that LinkedIn could not lawfully invoke the Computer Fraud and Abuse Act, the Digital Millennium Copyright Act, or common law of trespass. Affirming the district court's grant of preliminary injunction in favor of HIQ, the court concluded that HIQ established a likelihood of irreparable harm because the survival of its business was threatened. The panel held the district court did not abuse its discretion in balancing the equities and concluding that even if some LinkedIn users retained privacy interests in their information, notwithstanding the decision to make the profiles public, those interests did not outweigh HIQ's interest in continuing its business. Thus, the balance of hardships tipped directly in favor of HIQ. The court further held that HIQ raised serious questions going to the merits of the claim for tortious interference with contract, alleging LinkedIn intentionally interfered with contracts with third parties, and the merits of LinkedIn's business for business purpose defense. HIQ also raised serious questions as to whether state law causes of action were preempted by the Computer Fraud and Abuse Act, which prohibits intentionally accessing a computer without authorization or exceeding authorized access and thereby obtaining information from any protected computer. LinkedIn argued that once HIQ received its letter, any further scraping was without authorization within the meaning of the law. The panel concluded that HIQ had raised serious questions as to whether the references to without authorization limits the scope of statutory coverage to computer information for with authorization or access permission, such as password authentication, is generally required. Finally, the panel held that the district court's conclusion the public interest was favored in granting the injunction was appropriate. Separately, especially concurring, Judge Walsh wrote that he concurred in the majority opinion. He wrote separately to express his concern about appealing from a preliminary injunction to obtain an appellate court's view of the merits. Okay, so that's pretty simple, all things concerned. So what we have here is HIQ is a company that is scraping data off of LinkedIn, but they're only scraping data that's publicly accessible. So they're basically a search engine that's scraping data. And LinkedIn sent a notice saying, well, you can't do that anymore. And they're saying, well, look, we're just getting it off the public site. So you can't, it's not denying us permission. So I think all things considered, based on the reading of the law, I would tend to agree. The way this seems to be drafted. If you're putting information in the public, I don't see anything wrong with scraping the information off the public site. And I don't think that's a computer fraud and abuse, even if you've been told, please stop, because it's just public information. So all things considered, I'd say to agree where this is concerned. There was a question saying, doesn't it sound a lot like cases where search engines were sued and the Supreme Court said to get over it? Yeah, it sounds very similar to that to me. It basically is the same thing where there's just scraping information. It's like, look, it's in the public. All they're doing is documenting it. So it's like, yeah, it seems like the same thing to me. So, no major problems. I wonder if LinkedIn put it behind a robots.txt, if that would do the sufficient in order to deny permission. I don't know how that would go under the Computer Fraud Abuse Act, but that's typically how you do that with a robots.txt. So I don't know if they did that, and I don't know if it would make a difference, but that's the end of that decision. We're not going to read through the rest of it because we don't need to. That gives us what we need to know.